Hi, BADM 107 students. Hopefully by now you will have read the memo that I sent yesterday explaining the marking on the contract assignment. And hopefully you've received back your contract, you've had a chance to look at it, you've looked at the contract assignment grading memo so that you know how I did your marks. And this is the second video. The first one has been posted to YouTube. And it covers my explanation of the contract assignment grading memo, and it also indicates a couple of things that you have to know for the quiz, FOB and the Canada Interest Act. I think that's about all you have to know from there, but the quiz will be made up of the material that I'm going to go over in this video. And in doing so, I will be covering two documents that I've posted to eLearn, so you have to bring those up on your screen while you listen to my video. And the first is one called Contract Drafting. It's got a funny picture of a fellow with a magnifying glass trying to figure out what the heck a contract means. And the second one is about clauses in a contract and why they're important to dealers and the distributor in this particular sense. But those clauses are important to all people in those types of contracts. Okay, so looking at the contract drafting sheet that I posted, the first thing says form. Contracts may be oral, may be written, or may be partly written and partly oral. An oral contract is when you sell your textbook for this course after you've completed the term and after you've gotten a really good mark. You better get a really good mark. Anyway, you sell it to somebody for $60 and you say, yeah, I'll sell you my book. And they say, okay, I'll buy it. Bingo, it's oral, right? But if I'm selling you my car, I say I'll sell it to you for $2,000. You say I'll buy it. That's an oral component, but there's also a written component. There has to be a transfer document signed, and there has to be a check or cash transfer, right? So it's partly written and partly oral. And then we have the assignment that we did, where the contract is intended to be completely written. All right, we've gone over the parties a little bit, but I want to explain them in a little more detail. A trade name like Micro's Hard Computers or Bug Bash or Manufacturing are not legal entities in and of themselves. I'm a legal entity. If I have a corporation, it's a legal entity. But partnerships and sole proprietorships are not. Okay, so it would be Walter Wizzo doing business as Bug Bash or Manufacturing. So in the event that you want to contract with someone, you cannot contract with Bug Bash or Manufacturing because it doesn't exist. It's not a legal entity. So really the contract assignment should have been set up. Walter Wizzo doing business as Bug Bash or Manufacturing, bracket, and then you would say the dealer, manufacturer, and then you would say Dabble Distributing Inc., the distributor, right? Now, the contract wasn't with Dilbert Dabble, because if the contract was with Dilbert Dabble, he would then have to turn around and sell his rights to the corporation, and there could be double taxation there, okay, because he was getting it for his corporation. He wasn't getting it for himself. So a trade name, Nichols Bakery, Microsoft Computers, Starbucks, those are trade names. Those trade names may also be trademarks, but not necessarily so. Okay, then there's a company. It's an incorporated entity. It ends in Ltd, Corp, or Inc. Okay, not necessarily though. There are businesses like Bug Bash or Manufacturing Company, which are not corporations, because there's no law that says you cannot use the word company, all right? But you cannot use Inc., Ltd, and Corp unless you are actually incorporated. So sometimes you have to do a little bit more investigating when you have Sorry, I was just checking to make sure I was recording. When you have a contract with an entity and it's like Bug Basher Manufacturing Company, then you want to check and see if it's actually a corporation. Because after all, Hudson's Bay Company is a corporation and it ends in company. It doesn't end in Ltd, Inc. or Corp. Why not? Well, because it was incorporated in 1640 by going and talking to the King of England and saying, I want to be incorporated. They didn't even have a Corporations Act at that particular point. All right, subject matter. Goods, services, or a combination of goods and services. This was a service, a distribution agreement, plus goods could be sold at a later date. So it was a combination of the two. That brings into question, when you're talking about personal property of a tangible nature, what do we actually mean by that? And so we're now going to break down property into its two categories. Real property, which is land, buildings, and things permanently affixed to. Okay, so if I ask for the definition on the quiz, don't put down things permanently affixed to land, because that's only part of it. Okay, and you can't say land and buildings because that's only part of it. It has to be land, buildings, and things permanently affixed to. In this day of nuclear bombs, nothing is actually permanently affixed. But as far as the law is concerned, if to remove something from the land would cause a considerable amount of damage, then they consider it to be permanently affixed to. So obviously, if you remove a house from a lot, which they can do, then there's damage to the lot, and so the house is obviously affixed. The furnace inside the house is affixed, because to take out a furnace, you've got to take out ducting and electrical stuff and everything, so that would be affixed. But the table, the chairs, the beds, these things are not permanently affixed. They're just sitting on there, so they wouldn't be considered to be part of the land, real property. Trees. I'm looking out my window and there's this huge, nice, beautiful fir tree there. If that is removed, there's going to be a stump, there's going to be, slash everywhere, and there's going to be damage from the branches being cut down and everything. And so obviously trees are considered to be permanently affixed. Your driveway is permanently affixed, because to remove the blacktop would cause considerable damage. So those things fall under real property. Personal property, on the other hand, breaks down into two types: tangible personal property and intangible personal property. They used to call tangible shows in possession, because they were things you could possess, like the table that this computer is sitting on, the computer itself. These things you could possess, and so they were considered to be shows in possession. But things get a little complicated, because, for example, I'm just going to put it on hold until I can grab an example. All right, I actually had it in my pocket all the time. I didn't have to stop. But anyway, the toonie that I'm holding right now, I can possess it. But it's not really tangible personal property. Oh, it feels pretty tangible. But the problem is, it's a piece of metal worth a quarter of a cent, I don't know, and yet it represents more than that. It represents my ability to buy 2 donuts with this. So obviously, it doesn't fall into tangible personal property, but it's something you can possess. And so they've changed the definition. They now say tangible personal property are things that you can possess and which have value for what they are. This does not have value for what it is. It is just a hunk of metal. Okay? It represents value. So tangible personal property, what else have we got? We've got cars, we've got boats, airplanes, my mouse, all sorts of things that have value for what they are. This chair that I'm sitting on, oh, it's valuable for what it is. It's a chair that I can relax in. Okay, so those are tangible personal property. Intangible personal property are things that represent wealth. So a check for $10,000 is a piece of paper worth nothing, but it represents my ability to take it to the bank and get $10,000 for it. Patents, copyrights, trademarks, industrial designs, intellectual property, all are intangible. Okay, I think I've got a Mickey Mouse cup here. Okay, and it's hard for you to see, but there's a little R in a circle there because that is considered to be a registered trademark of Walt Disney. That's my favorite glass. Anyway, so you cannot possess a trademark, but your trademark represents the goodwill of your company. So because it represents value, it's considered to be intangible. So money is intangible. If I was in an accident and I wound up in a wheelchair, hopefully not, I would still be able to teach. Okay, so I would be able to sue someone for my inability to walk, but I would not be able to sue them for as much as a hockey player or a football player. A hockey player signs a contract for $1 million and then can't play because he's injured in a car accident and winds up in a wheelchair. Well, obviously, my right to sue someone for a personal injury is an intangible personal property, but the value depends on who and the situations. All right, let's think about it. Painting on the wall. I went to see the Mona Lisa in the Louvre in Paris, and I thought it was kind of small. I was expecting something bigger, considering it's worth about $25 million or something. Well, things get a little awkward there because I could possess the painting, and it would be valuable for what it is, the Mona Lisa, and yet there's also this intangible value to it. So the Mona Lisa is probably intangible personal property because its value is way above the actual painting itself. My mother-in-law, who's passed away now, was an artist, and she painted pictures, which we really like, and we have a number of them on the walls. But they would be tangible personal property because they're valuable for what they are. They're a painting that adorns the house, and they remind us of my mother-in-law. So it gets a little awkward with some things like that. Gold is another example. Now, all you young ladies with, your gold earrings and your gold necklaces and bracelets and everything, they enhance your beauty. Okay, so they are valuable for what they are. Okay, costume jewelry, not costume jewelry, valuable jewelry. And yet gold also has a value based on it being a precious metal. So if I have a gold bar, this would not be tangible personal property. This would be intangible personal property because I'm holding on to it because of its wealth value. Whereas if I have a gold watch, then I'm, probably fitting more into the tangible personal property category. Okay, so on the quiz, I could list various types of things and say, what are they? Are they real property? Are they tangible or intangible property? Pardon me. Now, a word that you bump up against quite often in law is chattels. So a car, a boat, chairs, chest of drawers, TVs, computers are chattels. They're tangible personal property. And we used to be able to take mortgages on chattels. We can still take mortgages on real property, okay? This is the mortgage you get when you buy your house. So it would be a real property mortgage. But you used to be able to take mortgages on chattels. So if you're a business person and you had a lot of equipment, you'd get a chattel mortgage to get financing for your business. That has been changed. We've modernized the law, and we now call it, when you're taking a charge over chattels, you now call it a personal property security instrument. Okay, and we have a Personal Property Security Act that I'll get into later on. Just as an aside, if you've ever gone to Barbados or somewhere in the Caribbean, there's all sorts of little catchy things that you can buy as souvenirs. And one of them is called a chattel house. And you think, oh, isn't that cute to buy a chattel house? In actual fact, that's probably not a politically correct thing to do anymore, because a chattel house was a house owned by a slave. Okay. Now, the landowners had slaves, and the slaves had to live somewhere, and they're certainly not going to live in the house with the owner, right? So they would build shacks. And, a slave and husband and wife and family would live in there. And then if the slave was sold to somebody else, this house was not permanently affixed to the ground, so they could pick it up and take it with them. And this was called a chattel house. Okay, and you can buy those as souvenirs, and I don't think very many people realize the significance of what a chattel house is. Okay. There was a clause in the distribution agreement called an assignment clause. And it says this agreement shall be binding upon and inure to the benefit of and respective parties hereto, etc., and may not be assigned in whole or in part without the consent of the manufacturer. I'm going to talk about this here, and it's also probably in the clauses document. But the significance of this particular clause is any contract, which, by the way, is an intangible personal property, can be assigned to somebody else. I have a contract, I'm a Wizzo, okay, and I have a contract where I'm going to get $20,000. Well, obviously that contract is just paper, and it's not very valuable as paper, but it represents my ability to get $20,000. So I could assign it to the bank, and then Dabble Distributing Inc. would pay the money to the bank, and in the meantime I could get some financing based on the value of that contract. So an assignment clause is intangible personal property, and it represents your ability to assign the contract. However, when it says it cannot be assigned in whole or any part of it, the reason that it says that there is Wizzo is giving his exclusive distribution rights to Dabble Distributing Inc. Because Dilbert Dabble is the born salesman. Hey, this guy could sell, anything to anybody, right? And so Wizzo thinks, wow, I'm gonna get Dabble Distributing Inc. to sell a fortune of these. Well, without that clause preventing Dilbert Dabble from assigning his company's contract to another party, Dilbert could do that. So he assigns his contract to Myron Entwistle, okay? And suddenly Walter Wizzo has a contract with Myron Entwistle to sell bug bashers. And, here's Myron. Hello, my name is Myron Entwistle. Would you like to buy a bug basher? No? Okay. So Myron can't sell to anybody, right? And so suddenly Walter Wizzo has, a really poor contract. So he using this clause, prevents Dabble Distributing Inc. from assigning the contract. The manufacturer can assign the contract, though, because Dilbert Dabble doesn't care who makes the bug bashers as long as they can make a lot of them and he can sell them. So that gives the manufacturer the right to assign the contract to the bank or to another company or whatever, okay? All right, so I'm going to talk about boilerplate clauses. And for years, lawyers were shooting themselves in the foot because a client would come in and they would have this agreement, just like Wizzo and Dabble. And they would say, draft me a contract. And the lawyers would put in what they call boilerplate clauses. And clients would say, this is stuff that the lawyer puts in just to beef up the contract and allow him to charge more. Well, that's not true. Boilerplate clauses, let's go back to the definition of boilerplate. A steam engine depends on pressure of the steam to drive engines. Okay. Well, that engine would explode because of that pressure, except they had boilerplate bolted on around the boiler to prevent it from exploding. So boilerplate clauses are designed to make the contract work to the greatest extent possible, just like the boilerplate was designed to make the steam engine work. One of those boilerplate clauses is the Inurement Clause. And if there's an inurement in the contract, and if you ran your contract through spell check, you probably changed it, which you shouldn't. An Interment Clause reads, all of the terms and conditions herein shall be for the benefit of the parties and their respective executors, administrators, representatives, successors, and permitted assigns. What's that mean? Well, I have a contract with a company. Dilbert Dabble dies, and his shares get sold to somebody else. So somebody else owns the company. They're different. Are they bound by the contract? Well, yes, because the executors, administrators of the estate of Dilbert Dabble are bound by this contract. So it's one of those important ones that helps the contract continue in existence in the event that somebody dies. Now, Walter Wizzo passes away. The estate is bound by the contract. Not that they're liable necessarily, but the estate is bound by the contract to try to perform it. Okay, so that's the Interment Clause. Then there's the Counterparts Clause, which you see in some contracts, not necessarily this one, but let's say, it could apply. Here we have Walter Wizzo in Vernon, and we have Dilbert Dabble in, let's say, Vancouver, and they have a contract. Now, is Dilbert Dabble going to go all the way to Vernon so the two of them can sign it together? Or is Walter Wizzo going to go all the way to Vancouver so the two of them can sign it together? They don't have to. You put in the Counterparts Clause, Walter Wizzo will have two originals of the agreement, and Dilbert Dabble will have two originals of the agreement. Walter Wizzo signs both and sends one without Dilbert Dabble's signature to Dilbert Dabble. Dilbert Dabble signs both and sends one without Walter Wizzo's signature to Walter Wizzo. Okay, so now Dilbert Dabble has the one he signed and the one Walter Wizzo signed. The Counterparts Clause says those two make a contract. So now Dilbert Dabble has a complete contract. Walter Wizzo, same thing. He's got one he signed and one Dilbert Dabble signed. Together they make a contract. So it just allows things to facilitate better. All right, the next topic is interpretation of contracts. And here we look at express terms and implied terms. An express term is one that the parties have said, okay, or written down. An implied term is one which the parties would have reasonably included had they thought about it. Okay, so back to the textbook, if you want to read about this, I think it's in there, is the SS Lotus, the SS Moorcock case. Okay, remember on my shield, my family crest, there was the moorcock. It's a very important English bird. Well, there was a ship named the SS Moorcock, and it was coming into a harbor, and the captain contacted the wharfinger, and he said, she's 40 feet long, and she's got 3 feet below the waterline. He's describing his ship, and he says, can I tie up at your dock? And the wharfinger says, yeah, sure, go ahead. So the captain ties up to the dock, the tide goes out, the boat goes down, a big rock pokes through the bottom, and the SS Moorcock sinks. So the owner of the ship sues the wharfinger, who says, hey, I said you could tie up. I didn't say it was safe to do so. Well, obviously, when this went to court, the judge said, well, wait a minute, come on, guys. He describes the length of the boat and how much of the boat is below the water line, what's he saying? Hey, look, and it's nice. It's painted red, and it's got a big smokestack, and it's got a propeller. It's like, no, he's describing the boat because it's important to the contract he's trying to make. So obviously, what he's saying is, hey, tides come in, go down, come up and down, up and down. Is it safe for me to tie up if 3 feet of my boat is below the water line? So the judge said this is an implied term of the contract. Neither party said, she's 3 feet below the water line, is it safe to tie up? And the wharfinger didn't say, hey, it's you can tie up, but it's unsafe to do so. So obviously, the judge said there's an implied term to the contract. Okay. So implied terms are ones that you would have included in the contract had you thought about it. The next one, the parole evidence rule, is in common law jurisdictions, not civil law jurisdictions. It's common law. And what it says is a term previously orally agreed upon between the parties shall not be allowed to add to or used to challenge a written contract. What's that mean? Well, I'll give you 2 examples. I had a client, a young fellow who was a real mover and shaker. He was an up-and-comer in the business community in Vancouver, good reputation. And he created the book of coupons called, it wasn't called the Entertainment Coupon Book, but it was the precursor of that. Okay, he came up with the idea. And he was doing really well. Well, his father was a driver mechanic for Budget Rent-A-Truck. And it was his job to fix the trucks and also move them around from location to location so that there were trucks available at their various outlets. His father got a 3rd drunk driving conviction and was fired, which you're allowed to do. It's called just cause, because you cannot have a 3rd drunk driving conviction person who obviously has a drinking problem as a driver for your company. It brings your company into ill repute. We'll get into that in Chapter 4 when we talk about employment law. But anyway, he got fired, and he had a mortgage and car payments, and things were looking a little desperate. So his son stepped in and was going to help his father. And he helps his father enter into an agreement to buy a fish and chip shop. And the agreement is reduced into writing, just like Walter Rizzo's contract was reduced into writing. The son comes in with his father into my office, and he says, would you please complete the purchase? Now, the contract is already signed, and I was reading the contract, and I went, there's nothing in there about whether this fish and chip shop is even making money. And so I awkwardly asked, is there any proof that this business is even viable? No financial statements attached. And the young fellow said, oh, yeah, don't worry about it, And I went, oh, okay. And then I went, whoa, no, I'm a lawyer. It's my job to worry. There's no financials. And how do you know it's making money? And the young fellow said, oh, because they told us it was. And I went, ooh. And I said, well, okay, just because they told you it was doesn't necessarily mean that's the case. And they said, no, we trust them. They're from the same ethnic background as we are, East European country. Now, I'm not prejudiced against East European countries. Okay, let's get that straight. But I thought, there's a problem here. Okay. Just because someone comes from the same ethnic background as you does not necessarily mean they're going to be honest with you. Now, most people are, okay. But you watch for red flags. And when he was telling me the story, he said, don't worry about it. They're the same ethnic group as me. And they're rooting around in their basement, and they've got some cash register receipts, which they're going to give us, which shows how much money it was making. And I thought, this is really bad. Okay, so I wrote a Cya Letter to my client. Now, I cannot say what a Cya letter is because I'd get in trouble with the dean. It's a Cya letter. you cover your letter. And I said that there are no financials, and that my suggestion was they give up the deposit and not go ahead with the agreement unless the vendors can prove that the business is making money. He said, no, go ahead. So I completed the transaction, and a couple months later, the young fellow was back in my office, and he says, I want you to sue them because that business wasn't making any money at all. And they were selling halibut instead of cod or something like that. And I said, well, I'm sorry, Tony. The problem is there's this thing called the parole evidence rule. Okay, if those things were important to you, they would have been in the agreement. And because they're not in the agreement, you're not going to be able to sue them. And they said, but they were lying to us. And I said, well, okay, maybe, but that's going to be really hard to prove because it's your word against their word, whether or not they even said that it was making money. And they're going to turn around and say, hey, we were doing okay with it, but you're a lousy businessman. You don't know how to run a restaurant. And it's going to get kicked out of the court because the parole evidence rule says oral agreements, it's making money, not included in the contract, cannot be used to attack the validity of the contract. That's because everybody would attack every contract that they didn't like, and the whole concept of an enforceable contract would break down. So the parole evidence rule is very dangerous, all right? Now, because people don't know about the parole evidence rule unless you sit up Saturday nights reading law cases, which I do, but then I'm a lawyer and I like that stuff, you're not going to know about it. And so what lawyers do when they're doing the boilerplate is they put in a clause called the Entire Agreement Clause. So the Entire Agreement Clause relates to the parole evidence rule. And what it does is it says this agreement, and I've got a copy on that form that I'm asking you to look at as you listen to me, represents the entire agreement between the parties with regard to the sale of the equipment herein and supersedes all prior oral and written agreements between the parties. That's to twig in your mind that if there's something like an oral agreement, you'd better put it in the contract. Okay, let's go back to Wizzo and Dabble to Serving Inc. Wizzo says, I'll give you 10 demos. So let's say Wizzo's a sharp operator, and he drafts up the contract and does not put the 10 demos in there. And you say, wait, I think we should put in the fact you're going to give me 10 demos. And he says, well, why would we put it in there? This agreement is what you're paying me for and what you're getting, and I'm giving that to you. And so, why would it be in a contract? And if they do that, your answer should be, well, okay, if it doesn't matter, let's put it in anyway. And if you go, well, I don't want to, redo it and everything. I'll give them to you. Don't worry. Little red flags should go up. Because an honest person would say, sure, it doesn't make any difference, let's put it in. And then it's in the agreement, it's part of the agreement, and you're going to get your 10. If it isn't in the agreement, he cannot give them to you, and there's nothing you can do about it. And you say, but it's part of the agreement. And the judge says, but you reduced everything into writing, so there's the agreement. If it was important, why didn't you put it in there? And Wizzo would say, and it's a gratuitous promise. I said I'd give them to you, but I'm not getting any consideration, so my promise is gratuitous, and so I can renege on it. And you're out of luck. That's the parole evidence rule. Another example. A woman came into my office, and she wants to buy a travel agency. Now, the fish and chip shop was not making any money. This travel agency was making money hand over fist. It was run by a Japanese resident of Canada, and he had 11 people working for him, and he sold Japanese tours. Very popular. Making money hand over fist. He had an operating corporation, which was also owned by a holding company. Okay, so he had two corporations for tax purposes. And he said, I wanted to sell it to you because I want to go back to Japan. He was Japanese and the woman was Japanese, a Japanese Canadian. And I said, okay, don't buy the corporations. He wanted to sell the corporations. And he said, I want to sell them because I don't need them anymore. I'm leaving the country. And so I want to sell them. And I said, do not buy them. Because the problem with the corporation is it could be sued. Or there could be somebody out there thinking about suing them. And you buy the corporation and that person sues the corporation. Well, you own the corporation, so that lawsuit is against your company. Whereas if you bought the assets and he kept his corporation and then somebody sues the corporation, you're okay. Because he owns the corporation, so it's his problem, and it should be his problem, right? You buy the assets, you don't buy the liabilities. And I told her that, and her answer was, it's okay because he's Japanese and I'm Japanese, and so he will not cheat me. So what I'm not saying here is that I am prejudiced against any group. What I'm saying is that there's two examples which show that if somebody's going to cheat you, it isn't going to matter whether they are from the same ethnic group or you, or is the same religion as you, or whatever, okay? If somebody's going to cheat you, they're going to cheat you. And so what you want to do is be as careful as possible. Most people are honest, which is a good thing. Some presidents aren't, but most people are. Okay, so, but if a person is honest and you say, I want to put it in the contract, I want everything signed and, you know, all the T's crossed and the I's dotted, and they say, yeah, sure, okay, that's good, because that protects both of us, then you're probably okay. But if they do start doing the dancing around routine and saying, well, you know, I don't want to buy the, you know, I don't need a corporation, so you buy them, then little red flags go up and you start taking additional precautions. Okay, so that's the parole evidence rule. The next topics are conditions precedent and conditions subsequent. A condition precedent is a term of a proposed contract that must be satisfied before the contract is actually final and binding. And this is really important in real estate transactions. I want to buy your house. No, let's put it back up. I want to buy a house, okay. But I can't pay all the money at once, so I have to get a mortgage. So if I go and get a mortgage, I start paying interest on it. And if I take 2 or 3 months to buy a house, or if it drags on for 6 months or something like that, I'm paying interest on this mortgage that I'm not using. So I don't want to get my mortgage right until I find a house. So then I find a house and I agree to buy it and I give you a deposit, and then I go to the bank and I say, can I get a mortgage? And for some reason they decline me. Well, I cannot get out of that contract just because I can't get a mortgage. I'm going to lose the deposit. So what you do is you put in a condition precedent in the contract of purchase and sale for the house. It's called a subject clause in real estate transactions, but it's a condition precedent. And it says, I will buy your house for $1,750,000, and I'm giving you a $50,000 deposit, subject to my ability to go to the Royal Bank of Canada and get a mortgage for, you know, X number of dollars at such and such an interest rate. Okay. Then if I go to the bank and I cannot get that mortgage, I can back out of the deal because there's a condition precedent that says it's not actually final and binding until such time as I get that mortgage. Well, that's kind of not fair to the vendor, all right? Because the vendor is going to sell you the house, and then he has other people that want to buy it, but he waits to see if you get your mortgage. You don't get your mortgage. He gets his deposit back, and suddenly the guy has to scramble and try to find some of those potential buyers. So that vendor of the house can actually put in a condition precedent as well, and it says, if let's see if I can figure out how this goes. If I get a full cash offer, I give you 72 hours notice that you either remove your condition precedent and buy my house, or I can back out of the contract with you and sell to the other buyer. Okay. So conditions precedent help out in contracts like that. Condition subsequent is a term of the contract which is in existence and binding. It's a future event, if it happens, can bring the contract to an end. So let's say a friend of mine, Brian, and I decide that we're going to go to a Vancouver Canucks hockey game, and we meet beforehand and we have dinner and a beer each. Except Brian doesn't drink at all, but let's pretend he does. And then we go to the game and we get there early because we want to watch the warm up, and we have a beer. And then the first period is about to start, so we go and get another beer, which you drunk watching the first period. And then between the first period and the second period, we have another beer. And then the third period, we get a beer to watch, or the second period. And then between the second and third period, we go out and we get a hot dog and a beer. Well, now I've had 4 or 5 beers, and Brian's had that many too, and we're actually blitzoed. And so we're standing up during the game going, "Go Lions, go! Go Lions, go!" And we're being obnoxious and we're spilling beer on everybody, and we're saying "Go BC Lions" because we're so drunk we've forgotten we're at a hockey game, not a football game. Well, on the back of the ticket that we have, it says that if we do something like that, they can actually break the contract and kick us out. Okay, so that's a condition subsequent. Another example is when you go to the P&E, the Pacific National Exhibition, which of course you probably can't because of COVID-19, but when you went to those things, or you go to Disneyland, you buy a ticket and then you go and you go, "Hey, wait a minute, the Indiana Jones ride is closed and the Splash Mountain's closed. Those are the 2 reasons I came." Well, read your ticket. It says that the ticket is binding, but that their requirement to provide you that part of the contract comes to an end. So that's a condition subsequent. Okay. The P&E says they have outside venues, which if it rains, they can break the contract to provide that to you because it's beyond their control. Okay. All right, signature lines. I'm going to tell you right now on the quiz. Am I giving something away? Yes, I am. On the quiz, there will be a question about signature lines. Okay. On the contract example, this was done terribly. Absolutely terribly by almost all of you, and everybody lost marks. Okay. In the very first lecture, I told you how to do signature lines when we discussed that check, and I told you that this was important for examination purposes and for the contract assignment. Nobody listened. I also said that was the only thing you should take notes on from my introductory lecture. I don't know whether you took notes or not, but anyway. Signature lines. You can identify the right parties at the beginning of the agreement, okay? But if you don't get them signed correctly, identifying them isn't going to help you. Signature lines for an individual. Let's say the contract is between Dagmar Francine and Dabble Distributing Inc. Well, for an individual, you have a line with their name under it, just like that, just like on the screen. You don't have to put on the contract individuals : okay? But if it's, so there should have been a line with Walter Wizzo under it. He signs it. It would have been better, and I would have got goosebumps, if you had said Walter Wizzo doing business as Bug Basher Manufacturing. What happens if it's Walter Wizzo and Wanda Wizzo, brother and sister, and they're in a partnership, Bug Basher Manufacturing? Well, you want to get one at least, but probably both of the partners. Okay, so you would have a line Walter Wizzo, partner. Okay, the reason you want to have Walter Wizzo and Wanda Wizzo, if possible, is because what happens if you enter into the contract with Walter Wizzo? Well, the contract is binding on the partnership. It's binding on both of them. The difficulty is when Wanda Wizzo didn't want to enter into the contract, and so they get into a dispute. They don't abide by the contract because they're fighting about it, and you have to sue them. Okay, so if you can get both partners to sign, then you know they both agree. The reason you only have to get one partner, and we'll get into that in Chapter 7, is because Section 7 of the Partnership Act says that a partner is an agent for the partnership. An agent can bring you into contracts. Okay. All right. Corporations, though, the example here was from a previous contract assignment, and the corporation was Net Your Customers, Inc. You have to put Net Your Customers, Inc. underneath that, a line with per in front of it. And in the world according to Peter Holden, you put Authorized Signatory under there. Per means on behalf of. So I have a corporation to prevent personal liability. Okay. So if I just sign, or if I sign and then underneath that line put per Net Your Customers, Inc., all I'm doing is incurring personal liability. Okay. And when I was in the introductory video, I said close. I had a client who said, "Oh, I remember Peter told me about this. What should I do?" Okay. I sign, and then underneath I say per Net Your Customers, Inc. And close enough. And then he sent the contract to me, and I said, "Hey, Ted, you're personally bound to that contract." And he said, "What? But I signed it, this way." And I said, "Yeah, close is only good in horseshoes, grenades, and nuclear war." Okay? It has to be precise because what you're trying to do is dodge liability, legal liability. And so the judge is going to allow you to do that because if someone deals with a corporation, they should know that they're dealing with the corporation and they take their chances. But they don't like you doing that. And so if you don't set up the signature lines correctly, they will make you personally liable. They sign per something, they go, "Oh, what you're saying is you are signing and agreeing to be liable for." But if you have the name of the company above it, what you're doing is you're saying you're signing on behalf of this corporation, and I have no personal liability. Authorized signatory, not absolutely necessary. But in the world according to Peter Holden, I think it's a good idea. Because when I say authorized signatory, am I an authorized signatory for me? No, I'm me. Okay, so I have to be an authorized signatory for someone or something else. So it's just one more nail in the coffin, which will prevent a judge from finding you personally liable. I used to tell my clients that for years and years and years and years and years, and most of them would do it. The World According to Peter Holden. And then I went to a continuing legal education seminar put on by the Law Society of BC, and they invited a lawyer from Atlanta to come up and talk about contracts. And I thought, why could they not find a lawyer from Canada, or for crying out loud from British Columbia, or for crying out loud from Vancouver that had the credentials to do that? They had to pay somebody to come in from Atlanta, Georgia. Anyway, she was talking about signing contracts, and she said you have to have the name of the company, you have to have per. And she said, and I think it's a good idea to put authorized signatory down there. And I went, yes. And she said, what? Pardon? And I said, oh, I'm sorry. I said, I always tell my clients that. And finally, I have some vindication. Okay, so you want to make sure that you send the contracts out correctly. Now, in the contract assignment, I said you had to be as fair as possible to both sides. If you are lending money to a corporation, you have to realize that if the corporation does not pay you back, you are not going to be able to go behind the corporation and get the owner to pay. So you should ask that owner to sign a personal guarantee. So there's the signature line, Dabble Distributing Inc. per authorized signatory. Dilbert Dabble signs, you've got the company on the hook. Now you want another line with Dilbert Dabble's name underneath it, and he signs a second time. Do you have him? Is he bound to the contract? No, he is not. Why not? Well, because the first contract, there is consideration going both ways. Okay. Walter Wizzo is getting $25,000. Dilbert Dabble is getting the distribution rights, the exclusive distribution rights to BC, excluding a specified area around Vernon. No, he's not. His company's getting that. So what's he getting? Oh, he's getting absolutely nothing. Oh, you mean he gets some benefit if there's a profit and it comes down and he takes a wage. But that isn't considered contract on the consideration on the contract. So because he's not getting consideration on the contract, it has to be signed under seal. I talked about seals in Chapter 3, and so it's a little red circle beside his name. It has to be affixed at the time or before the contract is signed. Intention to create legal relations. There has to be an intention to sign under seal. I'm going to put some material on eLearn about seals, and one of them talks about a BC case where a brother was selling something to his sister, and he signed the contract, and then he took his thumbprint and he put in some red ink, and he put his thumbprint on the contract. He goes, there you go, proves I signed it. And then he reneged on the contract, and the sister sued him, and she said, hey, he signed under seal. And the judge said, hey, a thumbprint like that is for identification purposes. There's nothing there that indicates his intention to sign under seal. Okay. So you should keep that in mind for the quiz as well. All right, security for payment. This is bringing this first part to an end, and so I want to talk about that. But just before I do, I'm going to take a short break. Okay, the last topic to discuss on the contract drafting document is security for payment. And I want to point out that you should do everything possible within reason to ensure that you'll get paid, but there's nothing you can do that will guarantee that you'll ever get your money except being paid in full up front, which doesn't work with a lot of contracts, particularly the Walter Wizzo contract. So the first thing on the list is retainer. For years as a lawyer, I would do the legal work and I'd bill my client, and there were a lot of clients who either decided they weren't going to pay me for some reason or couldn't pay me. So I started getting a retainer. If I'm going to do a shareholders agreement for you, I'm guessing that it's be about $1,500. So I get my client to pay me a $1,500 retainer up front. I do the work, I've got the money, and I'm happy. I had one client that really up-and-comer fellow that tried to help his dad and had a problem. Well, he also, in his own business, decided he was going to make a fortune. He decided to list on the stock exchange, got taken to the cleaners by promoters and fell on hard times. And then eventually he came back to me, and I actually wound up winding down his company, and it cost me about $300 in legal fees, and I couldn't get paid because he was defunct. Came back to me years later and wanted some advice on a contract. So I said, sure, come on into my office. And I said, it'll probably be $200 for an hour, so bring in $200. And he said, why? And I said, well, because, I'm going to give you advice and you're going to pay me. And he said, well, why do I have to pay you like right now? Like, why don't you, bill me? And then, 30 days from now I'll pay. And I said, well, are you going to pay me? And he goes, well, yeah. And I said, well, okay, I'm going to give you the work that you want performed right away, so pay me right away. And he said, but I can go to a lawyer downtown and they'll bill me and I'll pay later. And I went, yeah, but if you're going to pay me, why won't you pay me right up front? And he said, oh, well, okay. And so I made an appointment and he never came in. What he wanted to do, because he'd fallen on hard times, was come in, get advice on the contract, have me bill him, and then he wouldn't pay. And then am I going to take him to small claims court for $300? It would cost me more to do that than I would get. Okay, so you get a retainer up front, you prevent those problems. Now, Walter Wizzo cannot do that, okay? I mean, he could, but it's unlikely that Dilbert Dabble would do business with him. So Walter Wizzo has asked for a down payment of $5,000 because it is, as one student said, earnest money, okay, which shows their serious intention of Dabble Distributing Inc. to go through on the contract, and it covers some of the costs for Walter Wizzo. All right, so that's two ways. The third way is to retain title to the goods. Well, in this particular example, there are no goods being sold. But let's say I'm selling you some equipment for your office. I could sell you the equipment and give you title, and you could pay me later, okay? But if you don't pay me, how do I take those goods back? I sold them to you. They're your goods. I would actually have to go to court, get an order for seizure and sale. Remember, executing on a contract or on a judgment. Get a judgment, get an order for seizure and sale, grab the goods, sell them at an auction. Well, by the time that I do all that, the goods have disappeared and I don't get anything. So what I do is I say, okay, I'm going to sell you the goods. You're going to pay me over time, but I'm going to retain title. So if I retain title, I have the right to repossess the goods because they're my goods. But I have to have that clause in the contract, a repossession and acceleration clause in the contract. Otherwise, my goods are in your shop and I turn up to get my goods and you say, hey, if you enter, you're trespassing. And if I do, I am trespassing. So now I have to trespass and you'll get damages against me for trespass in order to get the goods that I want. Well, no, if I retain title to the goods, and have a right to repossess, then I can come onto your property to get my property, okay? And if you've paid me $5,000 and I sell the goods, then obviously the $5,000 plus the value of the goods sold gets deducted from what you owe me. The other thing you might want to include is an acceleration clause. And I've given you an example on the sheet. And what it does is it allows, now there's a series of payments. So you get the $5,000 and then on the December 15th, the check bounces or you don't get a check. Now the person is in default, so what do you sue for? Do you sue for that $10,000? Because the next payment on January 15th is not yet in default. So I'll wait until January the 15th and then I'll sue for 20. Wait, if I wait that long, the goods disappear and I get nothing, okay? So I want to be able to say, hey, you're in default, and immediately be able to sue for all the payments. This is like in a mortgage, okay? You get a mortgage for 15 years. Well, if the bank had to wait and sue you for each check that bounced or payment that wasn't made, it would be, ridiculous. And so they have an acceleration clause that says if you miss this payment, at their discretion, all payments become due and owing. It allows you to sue for everything and move quickly and hopefully recover something. Okay, but it says if the customer is in default of this agreement, the default continues for 10 days after written notice, then the supplier may terminate the agreement with respect to the may terminate the agreement with respect to whatever's owed. May. So the December 15th payment isn't made, and you get on the phone. Oh, I was going to do a rotary phone, right? So you get on your cell phone, hey, Dilbert, I didn't get your check for the December 15th payment. Dilbert goes, oh, for crying out loud. Okay, I'm sorry, just a mistake. I'll courier a check over to you right now. All right, fine. Then you don't have to discharge the contract and sue, right? So it's at your discretion. But if you go, this number is no longer in service, now you want to be able to sue for the full amount. All right. Sometimes, however, it's required by the nature of the agreement that you actually give title. So that means that you cannot go and repossess the equipment. So in this situation, what you do is you take a financing statement. You take a charge over the equipment that you sell under the Personal Property Security Act. Okay, so you list all the equipment that you sold, serial numbers or description of it to the best of your ability, and you pay a small fee to the provincial government, and you file a financing statement. And that financing statement says that you have a charge over that equipment. So in the event you're not paid, you get to take that equipment and sell it. All right? Now, the equipment goes into their premises, their leased premises. They haven't paid you. They haven't paid the landlord. They haven't paid a whole bunch of people. The landlord slaps a lock on the door, grabs the equipment, and sells it without checking the Personal Property Security Registry. All the landlord has done is sold that equipment for you, because you then go and you say, hey, I filed a charge in the government. You're deemed to know about that. You did not check. You grabbed the equipment, you sold it, so you now have to give me that money. Okay. So the landlord in a situation like that will contact their lawyer. The lawyer will check the Personal Property Security registry, and they'll say, okay, landlord, you're out of luck because that equipment is owned by, or pardon me, that equipment has a charge against it. Okay. This used to be the chattel mortgage, but they don't do that anymore. Now, right in the material it says, don't be confused by the word financing statement. This is not financial statements. Okay, financial statements are balance sheet, income statement, cash flow. Okay, you don't file those. That has nothing to do with this. You file what's called a financing statement, which is the government's name for the form that you file to take a charge. Okay. Letter of credit. Now, a letter of credit is a very, very secure way of being paid. I'm going to sell goods to another business, particularly, for example, if that business happens to be in Australia. So the problem with that sale is I want to get paid before I ship the goods to them. They want to get the goods before they pay you. So the way you get around this is you get the buyer to go to their bank, arrange a letter of credit. Their bank sends that letter of credit to your bank, and your bank tells you, hey, Peter, I have a letter of credit that says if you ship those goods, that bank will pay you. Okay, not the purchaser. The purchaser's out of the picture now. You're going to get paid by the bank. So I would rather have the Bank of Japan or Barclays Bank saying, hey, if you ship the goods to that purchaser, we'll pay you. And the letter of credit cannot be revoked by the buyer if it's considered to be an irrevocable letter of credit. Okay. So you designate, yes, I'll send you the goods if you give me an irrevocable letter of credit. You're probably going to get paid. Okay. Now I say probably because nothing is guaranteed. For example, you have to provide certain documents, and if there's problems with the documents, you don't get paid. Or if the bank is the really solid bank of Lower Lonsdale, maybe it isn't all that solid, and the bank goes under. You've got a guarantee from the bank that they'll pay you, but the bank goes under, and so you're not going to get paid. There are other things you can do, but we deal with that in international trade law. A separate course. Okay, letter of credit. Good way of being paid. Insurance. I'm selling you goods and you're going to pay me. You've got the goods, you've got title to the goods, or I keep title to the goods, doesn't matter. So I say to you, okay, you get insurance. If anything happens to the goods, we'll have insurance to make sure that you can pay me. And that sounds like, hey, guaranteed, you know. Not necessarily. The third largest insurance company in in North America, went insolvent. This is about 12 or 15 years ago. Okay, and all the people that had insurance with that company no longer had insurance. As it turned out, other insurance companies bought those policies, and everybody was protected. But if the insurance company goes under, you're in trouble. More importantly, though, than the insurance company going out is, I could get the insurance and cover the goods that I've given you, but why should I pay for the insurance to cover the goods that you're buying from me and I'm waiting to be paid for? So you should make the other side pay for the insurance. The danger there is that they go, yeah, okay, sure, and they don't get it. So what you say is, okay, I want you to get the insurance and give me a copy of the policy. Now I've got a copy of the policy. It shows they have insurance on those goods. Good, I'm safe, right? No, because now you've got a policy that says they've got insurance. What happens if they don't pay the premiums? Or worse still, they get in financial difficulties, and so they have paid some premiums and there's value in the policy, and they sell the policy back to the insurance company. The goods are destroyed, the company goes under, you go to the insurance company, oh, I'm sorry, that policy has lapsed. Okay, so what you do is you say, get insurance and make me the loss payee. Okay, what that means is if I have insurance of $100,000 on $100,000 worth of equipment and you've paid me $50,000, and then there's a problem, I get $50,000. I don't get $100,000. I just cover the loss, which should be $50,000, right? Okay, fine. But what happens if they don't pay the premiums? Well, before the insurance company revokes that policy, they will contact you and they'll say, hi, I note that you are a loss payee on this insurance policy. I just want to tell you that the premiums are not being paid. Okay, so you get a warning. Okay, there may be nothing you can do about it, but at least you'll be warned up front. Personal guarantee, we've already talked about that. If you're selling goods or something to a corporation and you're financing that corporation's purchase from you, you want to get a personal guarantee from the owner of that corporation or a director. Okay, it might be that there's 100 shareholders, and 100 shareholders are not going to give you guarantees, and it would become logistically a nightmare. So you would get a director of that corporation who is also an owner, okay, to give you a personal guarantee. Signed under seal. All right. Oops, last topic. I almost forgot. What about the pandemic? Okay, that's where the force majeure clause comes in. You want to have a force majeure clause in there that says if I cannot operate because of the pandemic, like Dabble Distributing Inc., okay, how do you go, hi, I want to sell to you and give you COVID-19 at the same time? So obviously, sales are impossible. Without the sales, he cannot pay you. He's in default. You sue, or the corporation is in default. You sue the corporation and you sue on the personal guarantee, and it's a nightmare. You want to have a force majeure clause in there, in the contract, just like there was in the dealer agreement. There wasn't in the distributorship agreement, so I was hoping you would say, hey, that would be a good idea, and you would take it out of the dealer agreement and put it into the distribution agreement. So you want to have a force majeure clause. And you want the force majeure clause to say that a pandemic is covered as an event which makes it impossible for me to perform, so the contract will be suspended until such time as the pandemic or the other problem is over. Okay, that nicely leads into the second document, the purpose of certain contract clauses, which I've posted to eLearn. And the very first one is talking about force majeure. So it says, why are the following clauses important? Well, it's important to both those parties, because what happens if Walter Wizzo cannot make the Bug Bashers because he cannot get workers safely into the workplace, and it's not a essential service, and so they may be required by a government order to shut down while the pandemic is raging. So he's in breach, but if he has a force majeure clause, the contract is suspended until he can get up and operating again. Conversely, it protects the distributor, because if he cannot sell, he doesn't have any money, can't pay for the contract, but the contract is suspended. Okay, then there's a clause in the agreement The distributor agrees that it is not and shall not represent itself as an agent. Why is this important to Walter Wiesel? So I give the distribution rights to Dabble Distributing Inc., and they go off and they sell 600,000 of these. And there's no way that I can produce that many to meet the contract. If they were considered to be my agent, then I would be liable. Okay. But if I have a contract with them and I say, hey, I can only provide you 1,000 per month, and they go out and they sell too many and they get sued, they cannot in turn sue me, okay, because they are not my agent. They're just a distributor. They're a separate business. They're not part of me. An agent is working for you. A distributor is working for himself. He's buying stuff from you and selling it, okay? All right, so it's important because you do not want the seller of your products to be your agent unless that's the relationship, okay? You may hire an agent to go out and sell for you. They sell, you have to abide by the contracts that they enter you into. But because Dabble Distributing is not your agent, they cannot enter you into contracts. Okay, status of the dealer. The status of the dealer shall be that of an independent contractor. Why is that important? Because you don't want that dealer to be, or the distributor to be construed as an employee. Okay? Because then you have to have employment insurance, workers' compensation. You have to make deductions and things like that. So you do not want the person that you're dealing with to be construed as an employee. No partnership created. This is extremely important because it suddenly looks like this might be some sort of a partnership arrangement. Well, the problem with that is Dabble Distributing goes out and it negligently injures 50 people that sue Dabble Distributing. Well, if you're in a partnership with them, you will be jointly and severally liable on that lawsuit. Jointly liable means you're liable with Dabble Distributing, and jointly and severally means if Dabble Distributing can't pay, you have to pay the whole shot. Okay, so you don't want to be construed as a partnership because of joint and several liability. That's the simple answer. Okay, so if I ask that on the quiz, why is that clause important? Because the parties do not want to be construed as partners because that would incur joint and several liability. The Interment Clause, we've already talked about that. You want somebody that takes over that company to be bound by it, by the contract. Okay, an even better example of that is if we formed a corporation and the corporation has a shareholders agreement that says in the event that one of us dies, we have insurance to pay off and their shares, okay? Because if you don't do that and one of the shareholders dies, those shares get transferred to their heirs or beneficiaries, and suddenly you have a shareholder in your company that you don't want, right? So you want that person to have to sell their shares back, but they're dead. So how do you do that? Is the representative of the estate, the executor, the heir, or whatever, are they responsible? Are they bound by that contract? Well, there's this thing called Privity of Contract that says no, they're not a party to it, so they won't be bound by it. So you want to make sure that the contract is, goes beyond death, basically. And then we've talked about counterparts. Why is that important? Just facilitates people in different locations signing contracts. Okay, so that's all the material which will be on the quiz. I think the quiz, it may be 5 pages long, but there'll only be something like 30 fast answer questions. Okay, and so I could put, for example, the relationship between the parties. Why is that important to the parties? And then there would, even though that would take up a lot of room on the paper, you very quickly say, oh, well, the answer is very short. Okay, the distributor does not want the Walter Wiesel does not want the distributor to be an agent because of contractual liability. Okay, so a really quick answer. Okay, and then there'll be signature lines. I've already told you. I expect everybody to know those. And quite frankly, I'm going to tell you right now, I suspect that they'll be done poorly on the quiz because you won't listen to me. And I'll put it on the final, and it'll be mandatory, because if there's a couple of things I want you to realize when you leave this course is how to identify the right parties in a contract, how to make sure you get the signature lines done, and what are the 6 binding elements of a contract. Okay, and I don't think it would be a good idea to forget everything else, but those are the things that I really, really think you have to be able to show me you can do that, or you'll have a hard time getting through the course. Okay, so that's all in this video. I will have a Zoom session before the quiz so that you can ask questions. And the quiz is, the date of the quiz, I don't know what it is, but you can find out because it's on the lecture schedule posted to eLearn. And I find it a bit annoying that I get people emailing me and say, hey, Peter Holden, when's the date of the quiz? When I've already posted it on eLearn. Okay, and you're supposed to look at the lecture schedule and see when you have to do the videos, when you have to do the problems, when the midterm is, when the quiz is. Okay, so get with the program, people. I should not have to go into eLearn and look and find out the date of the quiz and then go back and send you an email to tell you something that you can look up yourself. So I'm not sure when it is, but you can find out. And the week before that, we will have a Zoom session. Okay, now on the contracts, like I said, I could miss things or I could add up incorrectly. If I've done any of those things, you just highlight in yellow, send it back to me, and I will check. And if you are correct, I will adjust your grade. Thank you very much.